I'm going to be focusing on some of the key, most important elements of UK law and practice in relation to this area, some which are incredibly specific to the UK and differ hugely from foreign jurisdictions, particularly civil law jurisdictions. So this will be helpful both to practitioners, both in the UK and those abroad who instruct and oversee UK disputes through local attorneys here. Also too important to flag at the start, while some of what we're going to discuss does apply to patents, mainly unjustified threats, the focus of this webinar is on trademarks only. So we are applying the law under the UK Trademarks Act 1994 and the common law associated with that. So when I refer to section numbers, those are of the Trademarks Act, UK Trademarks Act. I've also set out this webinar by working through how a watching service works. I find this the cleanest and quickest way to put this area of law and practice into useful and quick perspective, make it tangible and approachable. And then, of course, it also allows me to provide some other examples, experiences, and anecdotes to give further context. The thing to note, I think the other point to note with common law is that the contents of the letter could also raise issues of common law estoppel. When I'm talking about estoppel, what we're talking about here is different to pure issue estoppel in IP office or court proceedings. If we take it back a step, the statutory defence of estoppel, which we're generally relating to here, relates to trademark acquiescence estoppel. And this entails a defendant arguing that the plaintiff was excessively slow, tardy in filing the infringement suit, and that the defendant relied on the silence of the plaintiff to assume an acquiescence of the trademark's use. So acquiescence estoppel is equivalent to tacit recognition manifested by unilateral conduct, which the other party may interpret as consent. From a UK perspective, statute is very clear on acquiescence. The knowledge must be of a registration or clear evidence of knowledge of use, evidenced by the defendant. And this is covered by section 48 of the Act.